times the appearance is what drives sales. People care as much or more about what it looks like. Does it look like something I want to have in my kitchen, as they do about the features? That's a big factor. And if it's a big factor in driving sales, shouldn't you be protecting?
You are listening to Intangiblia, the podcast of intangible law, plain talk about intellectual property. Please welcome your host, Leticia Caminero.
Welcome to episode 7 of the 3rd season. On this occasion, we're going to talk about design patents. We're going to talk about that protection that covers the aesthetics of a product. Let's welcome our guest.
My name is Margaret Polson. I'm an attorney and patent attorney in the United States. Our offices are just north of Denver, Colorado. I grew up here in Colorado and went to school here. Got my law degree from the University of Colorado and my undergraduate degree in molecular biology and biochemistry, also from the University of Colorado. I am, I'm going to have to stop and do the math, 54.
Great age, great knowledge.
I started practicing law back in 1996, so it's changed a lot. I started Polson Intellectual Property Law, which is my own firm, in 2014 after leaving another firm as a partner. And our firm is what we call an intellectual property prosecution firm. So we help people obtain intellectual property rights, patents, design patents, trademarks, copyrights, all of that. We're not a litigation firm. In the US in particular, litigation is a very staff-intensive and resource-intensive thing to do and expensive. And so as a small firm, we've decided to focus on the things that we're good at, prosecution, and work with other firms on litigation.
You help assist in securing rights.
Correct. And then most of our clients are small to medium-sized businesses. We do have some clients that are much larger, including some international businesses that have grown to that size. My client that most people would recognize is iFly Indoor Skydiving. So they're the ones that make the indoor skydiving wind tunnels. So they have tunnels all around the world, and we've helped them with their intellectual property protection. And then I ended up specializing in design patents, which is a particular type of intellectual property right, because of several of my clients, and I find them a fascinating area of law. So they're really fun to do and often undervalued.
So, what is a design patent? Let's dive into the topic. Yeah.
So a design patent is the right you use in the U.S. to protect the appearance of a product. So the statutory requirement is that it is the ornamental appearance of an article of manufacture. So it has to be something you can't just protect like an abstract design or something like that. You can with copyright. It has to be an article of manufacture. By ornamental, what U.S. law means is that its appearance can't be entirely dictated by function. So it can be functional. So an iPhone, obviously, its sleek shape is very functional, but its minimalist shape is a design choice, and those are protected by design patents. Design patents can be used to protect a very broad range of things, and they are. So anything from phones, you can protect graphical user interfaces with a design patent. You can protect more or less any consumer product, something that's going to be on the shelf. They're used a lot to protect replacement parts, so car auto parts, things like that. In some cases, jewelry, shoes, keychains, so almost anything that's manufactured can be used with the design patent. They've really grown in popularity, particularly as we reach the world of so much online copying. So, almost every brand has had problems with, they start selling their thing online and somebody starts selling a knockoff. And design patents, because they focus on the appearance, are much easier to enforce than a classic utility patent, because you just look at the drawings and look at the product. And if they're identical, well, you infringe. So they're a very good right for that kind of protection. The easy, let's get this thing off the internet, type of protection. If the appearance of your device is what's driving its sales, then let's protect the appearance. So they're very, they're very useful, right? I think people have become more and more aware of them in the last, say, 10 years. But I still think they're often underutilized. People overlook them.
Because they either focus on copyright, on the looking for protect an work art or an art or painting or some sort of work, or they focus on the function itself. So let's say the pattern, the inner works of the device, not necessarily how it looks. And
Correct.
what do you think is important to protect the design, to protect the appearance of a product?
There can be a lot of reasons. For the replacement part market, obviously a car headlamp is a car headlamp. You're not going to get a utility patent on it. But the replacement part market is for many, many brands a large portion of their income. The genuine replacement parts, that's a large portion of their income. So that it matters. The patent attorneys, that because design patents were sort of, for a long time, everybody was like, well, they're super easy to design around because you just have to make it look different. And so everybody sort of was like, there's no point in bothering to get one because they're just going to make it bother to look different. But what the current age of internet sales has taught us is they're not going to bother, right?
They're just going to straight out and copy.
It's just going to be a straight out copy. And they're gonna buy either your factory somewhere else is going to run a third run. You're running 2 shifts of the factory. They're going to run a third run and sell the exact copies. Somebody's going to get a hold of your molds because you turn over your molds quite quickly to maintain quality, and somebody grabs the old molds. The copies can be so complete. I've had copies that's marked with my client's patent number.
Wow. So
they changed
the last detail. There.
The last detail.
Wow. That's a very thought out copying.
Yes. And the other thing you can use, and the other thing about U.S. law versus the law of many European countries, in the U.S., copyright cannot be used to protect what's called a useful article. So furniture and many of those things, with some exceptions, that is a whole separate conversation. Copyright can't be used to protect those things. So you have to use a design patent. It's important to have that conversation early because design patents are a patent. They aren't examined right in the US. So they're like patents and trademarks. You have to convince an examiner that you're entitled to this. They are patents. So they are subject to all the US laws of patents. They have to be novel. Nobody has done this before. And non-obvious. So inventive step would be the European equivalent sort of thing. It has to not just be a small change. They have to be definite. So when you do a design patent, you submit drawings of your device. And it has to be clear from those drawings what the device looks like. So you can't just show 1 or 2 sides. You have to show it from all sides. If there's recessed areas or things like that, you may need to do a cross-section. And then in the U.S. patents, there's a 1-year statutory bar. So the 1 year after the first either offer for sale or public disclosure, either one, you can no longer apply for a patent. So you want to be sure to be talking to your intellectual property attorney early. Preferentially, you want to talk to them before you've launched the product. But if you come to us after it's been out on the market for 3 years, we're going to be like, well, we can't get a patent on it. So it is always important to talk to your intellectual property attorney early to make decisions about what you want to do. One of the other nice things about design patents, particularly for startups, is, utility patents are famously expensive to get. You're talking $8,000 to $10,000 to $20,000 to get a utility patent.
When you say utility patent, you mean the patent that protects the function of the...
Correct.
Mm-hmm.
Yeah. So utility patent protects what something does or how it does it. A design patent protects the appearance. So an easy example I often use is, automatic coffee makers when they were first made, when somebody came up with the way to, pump the water through and have a heater, have the heat plate and all of that, that would have been the subject of utility patent. Obviously, you can't get a utility patent on that now because it's known. But if you come up with a new shape of a coffee maker that looks different than everything else, then you could still patent on it, regardless of, the fact that, there's been automatic coffee makers for 30, 40 years now. But the new appearance of yours. And in the consumer world, oftentimes the appearance is what drives sales. People care as much or more about what it looks like. Does it look like something I want to have in my kitchen, as they do about the features? That's a big factor. And if it's a big factor in driving sales, shouldn't you be protected?
It makes or breaks a product now, the appearance, how it looks, how it feels in the hand, if it's ergonomic or not, or if it's the materials are used in a environmental conscious way. All that as well has a lot of great value in the market. Finding ways to protect the design, what makes it appealing, it's a way of also protecting your investment in this product.
Correct. And I mean, you can get design patents on the packaging, particularly consumer product companies protect, they spend a lot of money figuring out what's the unboxing experience going to be. What does it look like? How do you take it out of the box? Is the box interesting? All of those things. They spend a lot of money designing those boxes and how they fit together and all of that. And if you're going to spend all that money designing that packaging, shouldn't you be protecting it? And it also makes an easy way, again, the more rights you have, it also helps you fight against fakes. Fake electronic products are a huge problem, both from a safety point of view. I mean, a lot of the fires that you see caused by lithium-ion batteries are by, they're replacement batteries or they're fake batteries. The companies that are doing fakes on a large scale are all criminal enterprises. And oftentimes they're also involved in human trafficking, so all of these things that are bad about fakes, you can help prevent people from doing fakes of your products by having an easy to enforce right like a design. Amazon and most of the other online retailers will take something down based on a design patent. And that's a lot easier to talk them into than a utility patent. I mean, Amazon's process for taking something down based on a utility patent is very expensive and hard to do. But, the design patent, it's like taking out a trademark. You send them your design patent, they look and go, yep, that looks like it. Okay, we'll take it down. They're a very, very useful tool. And there's a lot of things you can do with them. Another thing that you can do in the US, there's and in many other parts of the world, there's a concept called trade dress. And that's similar. It's the same law as a trademark. So your trademark is your, the brand you're selling it under. Nike, Coca-Cola, Fitbit, Apple, Samsung. And things other than just the name can act as a trademark. So some of the more famous examples, the shape of a Coca-Cola bottle, Tiffany blue, the red shoe soles, those are things that you don't have to see the brand name. You know what they are from the thing. In the US, product configuration can serve as a trade dress, but it's never. You have to teach the consuming public that product configuration is your brand. So you can't just do it from the start. You have to teach the consuming public that this particular appearance is what you should look for. So look for this shape, look for this color. A design patent will allow you to protect your product shape while you're teaching the consumers that this is the product shape that they should be looking for. So they're an important part of your long-term branding strategy because of that. And another use for design patents in the US, we get a lot of what they call look-alike brands in the consumer world. So it's the same body lotion, so it's like, look like, similar to, or whatever. And the people making those brands will try and put it in packaging as close to yours as they can get away with. A design patent on your packaging lets you keep them away from that.
You are listening to Intangiblia, the podcast of intangible law, plain talk about intellectual property.
So how do I know if my design is patentable? What can I look for in my design, or how can I create a design with the
patentable
idea of making it patentable?
So it has to be novel. It can't look like anything that's looked like before, and it has to be non-obvious. So it has to be just not a minor change, so slightly changing the handle size. It has to be a different shape. In the U.S., law has recently changed with a case called In Re Surgisil that says what we compare to for novelty is limited to the type of product it is. So the case In Re Surgisil, but the item in question was a lip implant. So it was a metal implant to shape your lips from the inside. Not quite sure why you'd want to do that, but okay.
Sounds painful.
Yes, that's my thought. The item in question, the lip implant in question, was exactly the same shape as a drafting tool called a shading tool. So it was designed so you could shade your pencil and all that kind of stuff. So the shapes were identical. But obviously a drafting tool is a very different thing from a lip implant. The court ruled that in design patents, novelty is limited to similar articles. So if you've said this is a lip implant, then a shading tool is not what we call proper prior art that can be asserted against the patent to invalidate it. So prior art is everything that goes before you. And so you have to be novel and non-obvious over the prior art. But in the US, the courts just recently limited what is prior art. So that makes it both much easier to get a design because we only have to worry about your type of thing. It also on the flip side limits what you can enforce it against. So that cuts both ways. But for the vast majority of companies, I just want a patent on my thing. I don't care about other things. So
that's a great change to limit what is considered new. So it's only if it's inside the category, like in this case, the lip implant category, or
we don't know the exact things of what's going to be related prior art, but probably at least body. I mean, again, we'll have to see that. This is a very recent change, so we'll have to see exactly how it plays out. But one example, I mean, it's always been somewhat true. So in a design patent, if there's parts of the thing you don't care about in the drawings, you can do what's called put them in broken lines. So if you're looking at a design patent, there's solid lines and there's broken lines. The thing in broken lines is not claimed. We're just saying, yeah, it's there, but we don't consider that an important part of the appearance. You could always put more of the functional features in solid lines to make sure it didn't look like something before. One of my clients is a company called Bison Designs. And in the early 2000s, carabiners they're the things that have the inward spring gate that springs back automatically. And they were used for rock climbing and a lot of those kind of things. So you can, click in your things. And they started making them out of aluminum to be like keychains and bag holders and things like that. So they weren't going to be weight-bearing things to hold you up on a rock face. They could be ornamental shapes. But when they first started making them out of aluminum, everybody's just made the standard carabiner shapes. The founder of Bison Designs, Brian Kelligan, realized, well, if I'm making it out of aluminum and it's ornamental, I can make it any shape I want. So he made carabiners that was star-shaped and heart-shaped and all sorts of other ornamental shapes. And so we got design patents on all of these different shapes, and it's exactly the same heart you're used to. It is the exact same heart shape you're used to seeing. It's the exact same star, but nobody had made a carabiner out of them. And so, including a circle. We got, I joke that I got a patent on a circle, because we claimed the gate and all of that. But, Brian's soul, and I mean, this is one of those like never ask your patent attorney what they think of marketing, because if we could market, we wouldn't be doing that. But I'm like, who the hell wants a heart-shaped keychain? They sold millions of carabiners. I mean, literally millions. And so I'm like, okay, well, don't ask me what that means. But Brian created this whole new market of novelty-shaped carabiners. And for a long time, in the US, we were able to keep everybody else out of the market. He was able to sell a very large number of carabiners. So, as I said earlier, design patents are relatively easy to enforce. For the most part, we would send a letter to the company making them, and we'd be like, you're infringing our design patents. And they'd be like, oh, it does look like that. Sorry. But, how much should we pay to settle this? So they was very easy to enforce. We had a very successful enforcement campaign. We only went to court a couple of times, and it was very successful. And so it was definitely a learning process. That was my first client that really started doing a lot of designs. And it was definitely a learning process that I learned, design patents are very, very useful. And they're a very powerful tool. So
especially that you're explaining to us that it has a certain approachability that is they're easier to enforce in different scenarios, not only analog but also digital. So it may offer a faster, greater protection. That if you're a small business, you don't have necessarily the funds to pursue a great litigation or a great case, but by securing yourself a design patent, you may have a great tool that you can enforce without breaking the bank.
Correct. They're very useful for that. And they're a lot less expensive to get. So in the US, getting a design patent total, I mean, again, it depends and there's factors in there, but you're probably talking about $2,000, as opposed to, $6,000, $8,000, $10,000, $20,000. Design patents last for 15 years. In the US, they have no annuities. Once you pay your issue fee, you're done. It just sits there for 15 years and you got to keep enforcing it. They're a very powerful right when you know what you're doing and how to use them.
Yeah. So what are the steps to secure a design patent?
So the design patents are examined by the U.S. Patent and Trademark Office, the USPTO. There are design patent examiners. So we draft the application, and in case of design patents, it's going to be mostly the drawings. And you want to have a conversation with your attorney about, what parts do we care about? What parts don't we care about? There's obviously a lot of things you can do in there. We file the application with the U.S. Patent and Trademark Office. You want to make sure in the U.S. Inventions are owned by the inventor. You have to have a written assignment. So even if it's your employees, you want to get a written assignment that assigns the patent right over to your company. And then you apply to the USPTO. Currently, you're running about a year to get what's called your first office action. So in the US, anytime the USPTO, either in a patent or a trademark or a design patent, comes back and says, there's something we want you to do, or there's some reason we think something is currently wrong, that's called an office action. So it's called that across patents, trademarks, design patents. So the time to first office action is somewhere between 9 months to a year on average. Design patents have a very hot, because of the limitations of how narrow they are, that means that they're generally easy to get. The success rate in getting a design patent is about 95%. Most of them issue.
Wow.
Many of them issue without an office action. So the first thing you may get may be a notice of allowance. Many times the office action you do get is something minor. The USPTO is very, very picky about the drawings, much to the dismay of any foreign attorney who has tried to pursue a US design patent with the drawings that they got issued everywhere else in the world. So we may get an office action that just says something like, fix these drawings.
Draw better.
And then, And so we can respond to that. We can fix the drawings, and then we'll get a notice of allowance. You pay your issue fee, and you have a patent for 15 years.
Wow. It's easier than even a trademark from what you're telling.
In many cases, yes. In many cases, it is easier than a trademark because you don't have to argue with the trademark examiner about what's related goods. I mean, we may have to eventually now with the new case law, but currently it's like, no, this is, so there, we don't have to worry about the exact wording of which goods that you so often end up arguing with U.S. trademark examiners. Nope, I don't like that wording. It's like, oh,
it can be some difficulties as well, and also you have then to prove use on and on and on if you want to keep your trademark.
You have to come up with an acceptable specimen.
Yeah,
doesn't matter to the trademark office. Okay. To the patent office.
To the patent office. In design patent, it's have a good drawing first of all.
Yep, have a good drawing. Have good drawings. Yeah. Know what your product is. You do have to submit prior art. So in the U.S., design patents are utility patents. So what we call the duty of disclosure. You are required to submit all known similar things that you, as the company that owns it or the inventors, know about. For design patents, what I always recommend for my clients is just send me your past catalogs and your competitors' catalogs. We don't need to do a search. It doesn't have to be patents. For my clients that file things regularly, they just automatically mail us a copy of their catalog, and we just load it into the information disclosure statement. And so we file that as part of the thing, and then like I said, it issues. It's very easy. The other nice thing, currently in the U.S., cannabis products are becoming partially legal in so much of the world. You have a lot of problems protecting products around cannabis. So the packaging in the U.S., because it's not legal at the federal level, it's only legal in some of the states. You can't get trademark registrations on your packaging because it's not legal in commerce. So the federal trademark office won't register it. But I can get a design patent on my packaging because the patent office doesn't care.
That's a way around it.
So it is very definitely a way around it. Since Colorado was one of the early states to pass recreational marijuana being legal, we've worked a lot with our clients to figure out, okay, what are ways we can protect this given the federal limitations. So using design patents and in some cases copyright to protect the packaging, even though we can't get a trademark registration on that brand, has been very valuable for our clients.
It's a way to protect where there may not be another one as well. So it's if you cannot go to the conventional channels, then there's always, or there could be always, a door that you can knock that is a design patent door. Yeah.
And I mean, again, a lot of times, when I talk about design patents, I always encourage patent attorneys, if you're looking at doing a utility patent on a mechanical device, and to get around the prior art, you're going to have to describe in words exactly where all the pieces are. Well, maybe we should just do some drawings of where the pieces are and not have to argue with the patent examiner. If you're saying, that this lever is halfway down the face and this is over here, and you're physically describing in words exactly what this looks like, well, maybe stop and think, maybe this is better protected by a design patent.
Yeah. So don't tell me, show me.
Yes, don't tell me, show me. Yeah. And again, for small clients, $2,000 on a design patent versus $10,000 on a utility patent that may or may not issue.
It's a big difference. It's a big difference.
It's a very big difference.
Yeah, it's worth considering. And
I mean, utility patents. U.S. litigation is famously expensive to start with.
Mm-hmm.
Utility patent litigation is even more famously expensive.
You have to take off the hat on that.
it's a very different, easy work. It's a very different world. And then everybody's like, like I said, I mean, what you heard for years is, well, they just have to make it look different. Yeah, that's fine. If it looks different, it looks different, and it's not my product.
Exactly. So no one is going to think that they're buying my product. No one is going to think that they're getting my whatever product I'm protecting with a design patent. So it's something that it works in your favor.
Yeah. And I mean, in the US, as in Europe, you can protect you can do a patent on only part of the design. So let's say you come up with a really new, distinctive looking mug handle. Well, we can put the mug in broken lines and just protect the handle. And then it doesn't matter. Do you put it on a big tea mug or a small tea mug or whatever?
The core of my design, what is appealing to the eye, is this part. So this is the one that I'm going to look to for protection, because if not, then it's true. It can be placed in any type of other container, like tall, big, short. It will be protected anyways, because the core of my design is already acknowledged as a design patent.
Correct.
So let's summarize the benefits of having a design patent.
So design patents are, as compared to utility patents, they're easy to get. They're much cheaper to get. They're easier to enforce. They are a fairly flexible right, because you can pick how much of the design you want to protect. So do I want to only do part of it? Do I want to do all of it? It allows you to protect a broad range of other things. So packaging, replacement parts, the secondary, so what's often called the secondary market. One of my clients does shopping carts. And one of the things they want to protect, stores like to have all their shopping carts look the same. So you want to make sure they buy their second set of carts from you. So they're going to do a big first buy. And then over the years, as they get lost or damaged, they're going to buy more of them to add in. Well, you want to make sure that that they keep buying them from you. So if you have a design patent on your cart, or whatever thing that people might want to buy more of later, you can protect that further on market. So not just your initial market, but I want more that look like this. And that's true in the furniture industry, in dinnerware, like restaurant dinnerware, and all of that kind of stuff. I want something that looks like this, that matches. So that whole part of the market you can protect using design patents.
Yeah, because often those items become part of the identity of the business. So
Correct.
People recognize, like, this kind of item has belonging to this restaurant or this hotel or this supermarket or this store, because this is how they have been doing it for years. So just by looking at this item, you can immediately trace it back to the business. And that is something that whoever is making the item, it's important for them to protect it.
Correct.
Yeah, it makes perfect sense.
And then when you've had it that way long enough, you can morph that into your trade dress.
Of course. It's
a registered trade dress, and then
it's a win-win.
It's a win-win.
Yeah. And would you think of any success cases? I mean, we have talked about some of your clients, but anything that you would like to share with us, like a great anecdote of successful cases regarding design patents?
So I, until they were bought by Google, I was the design patent attorney for Fitbit. And one of the big markets for them that they weren't protecting or weren't successfully protecting was the swap out bands. So, there's all those different bands for a Fitbit. So you can have a more fashionable fit, band, or, change them out, change how they look. And we developed a design patent strategy to let them control that market, to control the alternate band market for their devices, where they were originally focused on just selling the devices. And then they realized that, many people were ending up with a collection of 10, 20 different bands because they wanted their bands to match their outfit, match their jewelry or whatever. And so we developed a program with Fitbit's in-house counsel to protect that market. and allow them to exploit that market far more than they had. As I said, with Bison Designs, he spent close to 20 years making, he literally made millions of dollars selling carabiners, aluminum carabiners. It's like, okay.
Shaped.
So it's a very useful thing. As I said, the replacement market. So for the shopping carts, that further on market. I have a client, GoLight, that was having a problem with fake lights. They're the ones that, literally had their patent number in the fake product. So that keeping that market, for them, that was a major part of the long-term success of the business.
Yeah, when you see this kind of infringement like that, like all the way, it adds insult to injury, right?
Yeah.
Like, okay, it's gonna be such an exact a replica of whatever your product is, and then I'm gonna make it even until the last claim in detail. I'm gonna put the patent there in your product. So wow, that must have been quite of a shock for them.
Oh yeah, no, we were like, what? Wow, but on the other hand, it was an easy letter to send, right? Where you write to their U.S. attorney, and we're like, so you copied it so exactly. Here's our patent number, and I got a phone call from their attorney, and he's like, so how much is this going to cost us?
Name your price.
So there was no arguing. There was no,
is there infringement? Is there not?
There's not infringement.
You were past that conversation.
Yep.
Well, at least something good came out of it. That's great. So, any last words of wisdom on this issue?
The main one is, talk to your intellectual property attorney early and often. And, when you start to go into other countries, be sure to ask questions, because the rules are different from country to country, and what you can do in Europe is different than what you can do in the US. But that can work both ways. You spent a lot of time thinking about the design and how to make it attractive. So, let's protect that as well. And don't get so, everybody wants, I need a utility patent, that's like the shining gold thing on a hill, for so many startup companies, we have to have a utility patent. I'm like, yeah, no.
Not really.
Not really.
Yeah.
So I think, it's, be flexible in your thinking, think about your intellectual property budget wisely. How much money are you spending versus, how many of these you're going to have to sell. And, have a really good conversation with your attorneys about what about this product do I want to protect?
Yeah. So look at the product and think how to protect it, not look at the IP and try to make it protectable, correct, like that. So it's
that is a very good way to put it.
Yeah. So it's the exercise is backwards.
Correct.
But thank you, Margaret. Thank you for your time. Thank you for sharing with us your great experiences. And we look forward to keep the conversation, to keep talking about this very interesting and not that well-known part of intellectual property, which is design patents.
Thank you for having me. It's always a privilege.
We have reached the end of our episode. See you next Tuesday with a new guest and a new IP topic. Greetings from Switzerland.
Thank you for listening to Intangiblia, the podcast of intangible law. Plain talk about intellectual property. Did you like what we talked today? Please share with your network. Do you want to learn more about intellectual property? Subscribe now on your favorite podcast player. Follow us on Instagram, Facebook, LinkedIn, and Twitter. Visit our website www.intangiblia.com. Copyright Leticia Caminero 2020. All rights reserved. This podcast is provided for information purposes only.